Okay, bye-bye.
Morning.
Hi, how are you?
I didn't pass.
No.
Thanks.
Yeah, it's Judge Cawthon today. She's gonna do she'll do the morning and then Judge Lerner Wren will do the afternoon. Now Judge Lerner Wren's doing the afternoon.
Okay, perfect, thank you.
Of course.
For the ones that come in, right?
Right.
Yeah. The ones that are cleaning at home, it's getting up.
Half the office is in here.
Really, they can't.
Right.
They get paid for it.
You
You're not
get
gonna get right.
you get, what's it called? Admin. No,
Administrative. Yeah, it's
administrative.
yeah.
Judge Powell. Hello? Yeah, sure. Hang on.
Hello? Yes, it's our phone. Yeah.
Here's Watson.
Domestics?
Yeah, this is Watson. So I'll
Oh, Watson, yeah.
put it in the background.
Yeah.
Wait, what?
Like they can do all of it. How many are there? Yeah. No, seriously. I mean, most of them I wrote here. That's something that you should tell for. So
Is he like not feeling good or not feeling good?
now I just wanted to take a off. Chili soul. Oh, because that was mine.
She does DVDs.
Yeah, yeah. I was mine because we bit the guy's hand and he had COVID.
Yeah,
Just having it on Wednesday and Thursday.
Oh.
Which division you in?
Stop chocolate.
This is the one where he was like driving in this restaurant.
Yes, exactly. I'm just saying, I mean, is it what, your money and then you do what you want?
Right,
Stupid.
that's pretty much what happened.
And I mean, good, you let her go, not kill her.
Jason. Goldsmith? Thanks.
All right. That one.
Is done with this? Are you done with that? Can I switch? No, I'm gonna switch it off here. Can I switch off here?
Erica, why don't you sit on this one?
Okay. I'm gonna, well, I'm gonna. What?
Got your seat with your cushion.
My cushion? My bag. I'm just gonna go in my hands.
Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak to your attorneys before speaking on the record this morning, because everything that we say here is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present here in the courtroom with me and are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are also able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that this morning I have in the courtroom with me attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on in your case and with you personally. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we are getting started this morning, I have two cases that Maine has requested to be called out of turn, so I will go to those first, and then I have one sign-in with private counsel, which I'll address after that. The first on my list from Maine is Frederick Thomas on page 12.
He's present, Your Honor.
Thank you. Good morning, Mr. Thomas. Mr. Thomas, you're before the court this morning on an ad charge. This charge is for second-degree petty theft, third or subsequent offense. I find probable cause. Is the state seeking anything beyond the standard bond?
Your Honor, the state will be keeping the bond in place. However, the state also wanted to inform the court that the defendant has a third-degree felony that's currently pending, and the state will be seeking to revoke bond at this time. Yeah, he has a pending.
Mr. Ferberick?
Judge, I can tell the court that he's lived here all of his life, that he works. He stays, I'm sorry, he does work. He also stays with his 72-year-old mom and takes care of her. He has 4 children, the youngest of which is 6 years old. He said that he has maybe $100 in the bank, but he's not even sure about that. He also had a medical issue in that he said that during the arrest, apparently his jaw was broken and he had a broken nose. They've taken x-rays of that. I would ask the court first for a photo order. I know we can't send somebody out there, but perhaps we can work it out with BSO to get photos taken of the injuries. So I would ask for that. The other thing that I would ask for is he does have other bonds, I believe, on the other 8 counts. I would just ask the court to ROR him with regards to this count, so that if he can make bond on the other counts, he'll be out on bond on those.
What are the other counts that are holding him? What's his other bond?
That I'm not sure of.
Judge, he's on no bond hold.
He has a no
Bonds
bond?
have already been revoked on 4 other charges.
Okay.
He has multiple possession of drug charges.
He does have a no bond hold in place right now. All right, in light of the no bond hold, I'm going to leave the standard bond in place in this case. All right, good luck, Mr. Thomas. I will also sign the photo order that was requested. Thank you. All right, next will be Shaquem Paul on page 16. All right. right, good morning, Mr. Paul.
Good morning.
Mr. Paul, you're before the court this morning on 2 charges. Count 1, grand theft auto. Count 2, battery on a law enforcement officer. I find probable cause, and I will hear from the parties at this time. He's out on bond in that case? The 12th of March? What's the case number?
202743 CF10A.
How much was the bond in that case? $1,000 on that one? Okay. All right. State, what's your recommendation on count 2?
Your Honor, state's recommendation is a $1,000 bond.
Mr. Farbrick, I'll go to you.
Judge, I would just ask the court to keep the other bond in place at 1,000 with regards to court case number 202743. In this case, I can tell the court that he's not working. He has no money in the bank, that his dad can hopefully post bond, but he's not sure again how much money his dad would have. What I would ask is if the court would consider making the bonds with regards to count 1 and count 2 $500 each, which would be a total of 1,000.
While I understand the circumstances that we all find ourselves in, due to the recency and the similarity of the charges in the other pending case that Mr. Paul's already posted bond for, the court is going to sua sponte revoke his bond in case number 202743 CF10A. I am going to order that he be held no bond in that case so that his division judge can decide how to handle it. He'll have a hearing on that shortly. With respect to the case that is before me today, I will leave the $1,000 bond in place on count 1, and count 2 will be $500. There will also be an order of no victim contact with respect to the grand theft auto case. Mr. Paul, so that you understand the no victim contact order with respect to the alleged victim, whether you know this person or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with that person. Do you understand that, sir?
Yeah.
All right, thank you very much. Good luck. All right, and now I have Mr. Lewis is present. On page 8, DeAnthony Cobb.
Good morning, Judge. Jim
Good
Lewis on behalf of DeAnthony Cobb.
Good morning, Mr. Cobb. Mr. Cobb, as you can see, your private counsel, Mr. Lewis, is present here in the courtroom with me. You are before the court this morning on 2 charges. Count 1, touch or strike battery, domestic violence. Count 2 is kidnapping while committing or facilitating the commission of a felony. I will hear from the parties at this time.
Judge, if I could, I'd like to make a probable cause argument on count 2, the kidnapping. There does
Okay.
not appear from reading the probable cause affidavit that there's any movement or aspiratation of the victim. And it certainly seems that the confinement, which is, I guess, the only thing the state would be arguing, seemed to be incidental and to the battery itself. So I think it's much more that that's a false imprisonment than a kidnapping. So I'm asking the court to find probable cause only as to false imprisonment and to set an appropriate bond as to that case.
Thank you. All right, state your response.
The state would respond that based on the kidnapping statute, that all of the elements are fulfilled here, that based on the facts of the case, that the victim in this case was being hit by the defendant. They were still driving. She tried multiple times to get out of the vehicle. The defendant forced her and restrained her by pushing her back inside of the vehicle. She continued to try to get out, and she was unable to do so. And it was against her will, and the defendant had no lawful authority to do so, and he acted with intent to do that.
Well, based on the allegations in the probable cause affidavit, I do believe that, at a minimum, there is probable cause for false imprisonment. Based on the information that I've been provided so far, I do not believe that that rises to the level of kidnapping based on the allegations that have been provided to me. So at this time on count 2, I am going to make a probable cause finding as to false imprisonment, and I am going to make that indication on my finding sheet. For the record, I do find probable cause for count 1.
Judge, Mr. Cobb's lived in the community a long time. I'd ask for bonds like $1,000 on count 1 and maybe $5,000 on count 2. I think that's what I'm asking for.
State your recommendations.
Your Honor, with regards to count 1, the state would be asking for a $1,000 bond amount, and then count 2, the state would be asking for $50,000.
Mr. Cobb have any prior history?
Yes, Your Honor. In 2007, he had a robbery, sudden snatching, and 2014, there was a domestic battery that was dropped, and 2017, domestic violence that was dropped, and that was it.
He had other priors also. Were they most recent ones?
Bond on count 1 will be set at $1,000. The bond on count 2 will be set at $10,000. There will also be an order of no victim contact. Mr. Cobb, so that you understand the no contact order with respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes.
Thank you.
Thank you, Judge, very much.
All right, before I start with our regular list, is there anyone that the jails need requested called out of turn at any of the jail facilities? Okay. Next on my list will be Deidre Martin.
May, she's approaching.
Thank you. Good morning, Ms. Martin.
Good morning.
Ms. Martin, you're before the court this morning on one charge of touch or strike battery. I find probable cause. Is the state seeking anything beyond the $1,000 bond?
Just no victim contact, Your Honor.
All right, Mr. Fabric, I'll hear from you.
Judge, I would just ask the court, she's lived here for approximately 8 years. She's single. She has some money in the bank, but not a lot. I would ask the court to consider setting the bond at $500.
Does Ms. Martin have any priors?
Just 2013 petty theft withhold. That's state of Florida prior that I see.
All right. The bond will be set at $500. There will be an order of no victim contact. Ms. Martin, so that you understand that no contact order with respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes.
Thank you. Sharonice Gonzalez.
May jail, she's approaching.
Thank you. Good morning, Ms. Gonzalez.
Good morning.
Ms. Gonzalez, you're before the court on 3 charges. Count 1, aggravated battery causing bodily harm or disability, dating violence. Count 2, battery, second or subsequent offense, dating violence. Count 3, driving while license suspended without knowledge. That is not for magistrate. I find probable cause, and I'll hear the parties' recommendations, beginning with the state at this time.
Your Honor, the state will be requesting for count 1 a $2,500 bond amount, and for count 2, $1,500 bond amount with no victim contact.
Judge, she's indicated to me she's lived here all of her life. She has no money in the bank right now. She's still a high school student. She goes to Hallandale High School, so she's not currently working because she is in school. Her family members live here in the area. She lives with her mom. She said her mom will help, but again, I don't know the amount of money her mom would have to potentially bond her out.
Does Ms. Gonzalez have any prior history?
No, Your Honor.
Judge, I would just also note counts 1 and 2 are kind of duplicative, just in the sense that it was basically it was a battery. She allegedly, I guess, hit them with a knife and cut somebody. That's the allegation.
Well, in addition to the allegation that she intentionally struck the alleged victim's vehicle with her own vehicle while he was in the car. The bond on count 1 will be set at $2,500, and the bond on count 2 will be set at $1,000. There will be an order of no victim contact. Ms. Gonzalez, so that you understand that order with respect to the alleged victim, it means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
Thank
Am I
you.
allowed to say anything? Talk if you want to.
Dana
Hello,
Myers?
ma'am?
Yes, ma'am.
Hello, ma'am? Can I say that I didn't?
I do not want you to say anything about the facts
Okay.
of the case, okay? Today is just about bond and release conditions.
Okay, ma'am.
All right, thank you very much. Good luck. Next will be Dana Myers, North Broward.
No problem. Good morning.
Thank you. Good morning, Deputy.
Hello.
Good morning, Ms. Myers. All right, Ms. Myers, you're before the court this morning on a misdemeanor capias that is related to a charge for resisting or obstructing without violence. I find probable cause. And Mr. Farbrick, what would Ms. Myers like to do today?
Judge, she wanted to try to resolve the case if possible this morning.
Is there an offer from the state?
Yes, Your Honor, the state's offer is an adjudication time served.
All right,
Thank you.
Ms. Myers, do you understand that offer?
Yes,
And do you wish to accept that offer to resolve this case today?
yes.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes,
Thank you, and now you can put your hand down. And Ms. Myers, do you understand everything we've discussed so far this morning?
yes.
Is anyone forcing you to resolve this case?
No.
All right, are you under the influence of drugs or alcohol? Ms. Myers, are you under the influence of drugs or alcohol?
Well, yes,
You are under the influence of drugs or alcohol?
but it's not that. It's because I'm working.
Mr. Farberg, did you have an opportunity to speak to Ms. Myers? Hold on one second, Ms. Myers.
I did, Judge. There were initially some concerns. I did
Oh,
question her
ma'am.
with regards to if she had consumed any drugs or alcohol. She indicated she didn't. She then became a little bit more coherent and was able to discuss a little bit more with me.
Okay, well, I'm asking because I know that, right now, our afternoon magistrate sessions are being presided over by Judge Lerner Wren. So if there may be an indication of a problem, then I could reset her to the afternoon docket to let Judge Lerner Wren maybe explore a little bit further
No.
with her.
Do that, Judge.
All right, so, in Ms. Myers' case, I'm going to have her reset to the afternoon docket today. All right, thank you, Ms. Myers.
Okay. Thank you.
All right, next will be Michelle Brooks.
Correct.
All right, good morning, Ms. Brooks.
Good morning.
Ms. Brooks, you're before the court this morning on a misdemeanor capias that is related to a charge for trespassing. I find probable cause, and Mr. Farbrick, what would Ms. Brooks like to do today?
Judge, she does wish to try to resolve the case this morning.
All right, is there an offer from the state?
Yes, Your Honor, the state's offer is an adjudication time served with no return to the location.
All right, and Ms. Brooks, do you understand that offer?
Yes, I do, ma'am. I will never return to the budgeting on
Scott Street ever again. I mean, I may
All right,
go around.
that's okay. That's all I needed to hear, okay? All right, so you wish to accept that offer and resolve this case today?
Yes, am I allowed to, however, cruise through the parking lot if necessary?
I
To
don't
see
want
my
you,
friend?
I don't want you to be anywhere on that property. That includes the parking lot, all right?
Okay.
Okay.
Yes, ma'am.
Okay, all right. So Ms. Brooks, I'm gonna ask you a few questions before we're done. Okay?
Yes.
To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Correct. Yes.
Thank you. Now you can put your hand down. And Ms. Brooks, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
Currently?
Currently. Are you currently under the influence of drugs or alcohol?
Well, ma'am, that's a very difficult thing to answer because, well, yes, because.
Okay, well, let me
I've
ask
done
you
them
this. Hold on, Ms. Brooks. Other than any prescription medication, are you under the influence of drugs or alcohol?
Yes.
Mr.
Judge,
Freiberg?
I did have an
Hold
opportunity
on,
to
Ms.
speak to her. She was able to answer all my questions. I didn't have any concerns with regards to any issues with her understanding.
Okay. Ms. Brooks, are you under the influence of anything that may impair your judgment at this time?
No, ma'am.
Okay. Are you able to understand everything that we're discussing here today?
Yes.
Okay. All right. Do you need any more time to speak with your attorney?
No.
All right. And do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
That is correct.
All right. Have you ever been treated for mental or emotional illness?
Yes.
Okay. Is there anything about any mental or emotional illness today that impacts your ability to accept this plea?
No.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
Okay. And Ms. Brooks, what plea do you wish to enter? Guilty or no contest?
No contest because it's already been.
All right. That's fine. I accept your plea and find that it is freely and voluntarily given. And once again, your sentence will be an adjudication of guilt with time served. And remember, there will be a no return order to the location that we discussed. And you understand that?
Yes, ma'am.
All right. Thank you very much, Ms. Brooks. Good luck to you.
Thank you, Judge Cossaran.
Thank you.
Thank you.
Thank you. All right. Next will be Teresa Stewart. Thank you. Good morning, Ms. Stewart.
Good morning, Your Honor.
Ms. Stewart, you're before the court this morning on 2 charges. Count 1, robbery with a firearm. Count 2 is a traffic capias related to a charge for operating without a valid license. I find probable cause, and I will hear from the parties, beginning with the state at this time.
Your Honor, the state will be asking for proof evident presumption great in this case.
You're requesting a no bond hold on count 1?
Yes, Your Honor.
All right, Mr. Farbrick, I'll hear your response.
Judge, we would just respond that that's the highest burden that the state would have to prove. I would just ask at this time that the court, especially in light of the fact of the pandemic that's going on, the court not find proof evident presumption great. If the court decides to find proof evident presumption great, I would ask the court to use its discretion in setting a bond. I can tell the court that she's lived here all of her life, that she has 3 kids that range in age from 7 down to 6 months old. She only has a few $100s to post bond, but we would just ask the court to allow her to potentially post bond in this case.
Okay, I have reviewed the probable cause affidavit in this case. I believe that her co-arrestee was actually in front of me yesterday, so I'm familiar with the information in the probable cause affidavit, which I re-reviewed this morning. Based on that information, at this time, the court is going to make a preliminary finding of proof evident presumption great and order that Ms. Stewart be held no bond on count 1. That will be without prejudice for her to have the appropriate Arthur hearing before her division judge. My understanding is that our felony judges are actually holding hearings even with everything that's going on right now, so she will have the opportunity to do that. And in light of the no bond hold on count 1, I'm going to leave the $500 bond in place on count 2. In an abundance of caution, there will also be an order of no victim contact. Ms. Stewart, so that you understand the no contact order, with respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, ma'am?
Yes, ma'am.
All right, thank you.
Thank you.
Shamel Jeff.
Angel,
Thank
she's
you.
approaching.
Good morning, Ms. Jeff. Ms. Jeff, you're before the court this morning on one charge of failure to redeliver a hired vehicle. I find probable cause. Is the state seeking anything beyond the $1,000 bond?
No, Your Honor.
All right, Mr. Farberg, I'll go to you next.
Judge, the only thing I can tell the court is that she's lived here all of her life. She has 4 children. She's not currently working and has no money in the bank, so I don't know that she'd be able to afford the $1,000 bond. She does have family members that are here, but she's not sure if they're going to be able to help her post bond or not.
Your Honor, she is out on bond on a bond report.
When was she put on bond in that case?
August 10th, I think, 2019.
All right, I'm not going to take any action in the case that she's out on bond for, but I will leave the standard bond in place at this time. If she's unable to post it, I believe she would still come up on our second docket, so if we need to readdress it, we will. Grace Johnson. Is she still medical? All right. Rebecca Selby.
Good morning, Your Honor. Paul Ryan.
Thank you, Deputy. Good morning.
Good morning. Unfortunately, Miss Shelby again refuses to show up.
Okay, this is a refusal.
Yes, ma'am.
All right. Well, I do see that this is a felony VOP, and her division judge has already placed a no bond hold. So at this time, I'm comfortable with making a probable cause finding in absentia, and her division judge will be able to address that no bond hold. Thank you, Deputy.
Thank you, ma'am.
All right, next will be Rosa Ellington. Bonded. Thank you. Kyle Spellacy. What does that mean?
Yes.
Okay.
What's your name?
Kyle Spellacy. I'm sorry, who do you have there, Deputy?
Rosa Ellington.
Okay, Miss Ellington, your bond was posted. So you'll be processed for release. Thank you. Next will be Kyle Spellacy. Good morning, Mr. Spellacy. I'm well, thank you. All right, Mr. Spellacy, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I will hear the parties' recommendations, beginning with the state at this time.
Your Honor, based on this prior and facts of the case, the state will be requesting a $3,000 bond with no victim contact.
Okay, Mr. Farberg, I'll go to you.
Judge, he's lived here all of his life. He has one child that's 2 years old. He works as a server, so he may be unemployed at this point, based on what's going on at this time. What I would ask is if the court is going to set a bond in the case, I would ask for a minimal amount of $500.
What are his prior state?
2012 robbery, no weapon adjudication. 2012 strong armed robbery, robbery, no weapon, attempted robbery, no weapon, possession of alprazolam adjudication. 2012 aggravated battery, great bodily harm adjudication. 2011 a juvenile case, burglary, dwelling with a battery, found delinquent in juvenile court.
Is 2012 the most recent?
Yes,
All right.
that's the extent of the floor price.
All right. I will set the bond at $1,000, and there will be an order of no victim contact. Mr. Spellacy, so that you understand the no contact order with respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person until further order of the court. Do you understand that, sir?
Yes, ma'am.
Thank you. Next will be Leandro Gonzalez Valdez.
Man, he's approaching.
Thank you. morning, Mr. Gonzalez.
Morning.
You're before the court this morning on a misdemeanor violation of probation. I find probable cause. And Mr. Gonzalez, this currently has a no bond hold on it, which means that your division judge will be the one to address this case. So you should be seeing them soon. All right, good luck to you, sir. Next will be Todd Watson. Thank you. Good morning, Mr. Watson. Mr. Watson, you're before the court this morning on an ad charge. This is count 5. The charge is aggravated stalking after an injunction for protection, domestic violence. I find probable cause. And state, I just want to confirm, I believe that the other charges that Mr. Watson has right now were also for the same charge. Is that correct?
It's for new victims, Judge.
Correct.
But the same charge, that's correct.
Okay, and did Judge Stone set those at $100,000, I believe?
I believe so, yes.
Okay, all
Judge,
right.
I'm
Yes.
sorry, also, just so the court knows, he wanted to, he indicated he declined the public defender, he wants to represent himself.
Yes, I'm aware. I'm aware. I know that Mr. Watson just had his initial hearing this week. All right. Okay, so, and I also just want to confirm, I believe Mr. Watson has a no bond hold also. Is that correct, confinement? Okay. All right, Mr. Watson, in light of the bonds that you have on the other accounts and the no bond hold that you have right now, I'm going to go ahead and set this one at $100,000 as well, and there will be an order of no victim contact. With respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, I do. I have a couple issues that I'd like to bring up, though.
All right.
My case is supposed to be assigned by executive order.
Right.
It was discussed that it was supposed to go down to the Dade County. Dade County cannot hear this case because they, in fact, intentionally continued to prosecute me after Governor Rick Scott denied the extension of Executive Order 17-213. So they cannot hear it. So Broward County nor Dade County can hear my case.
Okay.
Also, I'm asking very nicely to please allow me to hire or request the assistance of a shadow counsel. I know that I'm allowed to do that. I don't know if I can pick my own. I'm not sure about that. I did not research that.
Mm-hmm.
And I also would like use of the pro se phone here.
Okay. Well, Mr. Watson, you can absolutely hire your own counsel at any time. Number one, I'll
No,
just tell you that.
shadow counsel can be assigned to me through the court.
Okay. Well, I don't have that before me today. If you have a proposed order that you're able to get to me, then I will sign that. As far as use of the phone there at the jail goes, I know that they have their own procedures for phone use. So whatever those procedures are, I don't have control over them. And with respect to...
You can order use of the pro se phone on my behalf as a
Okay.
pro se litigant.
Okay, that's fine. Then I will sign that order for you so that you're able to do that, okay? As long as you understand the no victim contact order, so no making phone calls,
Absolutely.
okay? And Mr.
Absolutely.
Watson, with respect to the other issue as far as Dade hearing it, unfortunately, I'm not able to address that issue today since this is just the
Okay.
bond hearing. But I do
Okay.
have on the record that you're making that known, okay?
Okay, but I have had it ordered for me before for the judge that they had assigned me a shadow counsel. So you can, put forth that order to assign me a shadow counsel, please.
Okay, all right, Mr. Watson, I'll sign the orders for you, okay?
Thank you very much.
All
I
right.
appreciate it.
Thank you. Guys, is this for the case that I revoked the bond on? Because you have to actually write in there that the bond is being revoked. You can't just write it like that. So, somebody fix that, please. All right, next will be Fitzgerald Thomas.
Morning, Your Honor.
Good morning, Mr. Thomas. All right, Mr. Thomas, you're before the court this morning on 3 charges. Count 1, touch or strike battery, domestic violence. Count 2 is a misdemeanor capias related to a trespassing charge. And count 3 is a felony probation violation, which has a no bond hold. I find probable cause, and I realize that Mr. Thomas has a no bond hold that will have to be addressed with his division judge. However, I will hear recommendations from the parties as to count 1.
Your Honor, the state will be recommending for count 1, $3,000 bond based on the facts in the case and plus his record, his priors.
Mr. Farberg, I'll go to you next.
Judge, in light of the fact that he's being held to a bond, I would just ask that the court set a $500 bond.
All right, I will set the bond on count 1 at $2,000. There will be an order of no victim contact. Mr. Thomas, so that you understand the no contact order with respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person until further order of the court. Do you understand that, sir?
Yes, ma'am.
Thank you.
I'll be able to bond out?
Sir, you have a no bond hold right now, which means that your division judge will be the one to address that, so that hearing should be set soon and you'll get notice of it.
Okay.
That's a Dade County hold? Okay, all right, that's a Dade County hold, okay. All right, so next will be Jacob Martinez. Good morning, Mr. Martinez. Sir, you're before the court this morning on 5 charges. Counts 1 and 2 are felony capiases, which have no bond holds. Counts 3 and 4 are felony warrants for violation of pretrial, which also have no bond holds. Count 6 is a misdemeanor violation of probation, which also has a no bond hold. I find probable cause. And Mr. Martinez, because of the no bond holds, you'll have to go before your division judge to address those matters. So that hearing should be set shortly and you'll get notice of that. Thank you. Good luck. James Franklin.
Long, let go long now.
Okay. All right. Thank you. Gordon Cleary.
Major, he's approaching, ma'am.
Thank you. Morning, Mr. Cleary.
Yes.
Mr. Cleary, you're before the court this morning on 3 charges. Count 1, trespassing on an occupied structure or conveyance. Count 2, removal of a shopping or laundry cart without written authorization of the owner. Count 3 is a misdemeanor warrant for violation of pretrial, which has a $25 bond that is not for magistrate. I find probable cause, and I will hear from the parties.
Judge, I believe he wanted to try to resolve this if possible today.
Well, the violation of pretrial is not going to be able to be resolved, just so that you're aware.
Mr. Clear, I would just ask you, are you able to post the $25 bond that's set for the violation of pretrial?
Go ahead, say it one more time.
No.
Okay. And Judge, I don't know if you can consider RORing him with regards to that count. I don't want that to hold him from getting out.
The issue is that, number one, I do know that the division judges are available to hear those hearings, so I'm not necessarily inclined to do that, especially in light of the fact I believe that the issue here is that Mr. Cleary was here recently on very similar allegations involving the same location. I do remember him. And the violation of pretrial is for failure to report and enroll in pretrial services. So I'm not inclined to ROR him on that.
So, Mr. Cleary, here are your options. You can either try to resolve counts 1 and 2 this morning. You would have to go back in front of your division judge with regards to count 3. It's a $25 bond. So even if you resolve 1 and 2 today, you wouldn't get out unless you post that bond. Or you can just wait and take care of everything altogether.
Tear it all together.
Okay.
Okay, so I'll leave the bonds in place as they've been set, and his division judge will be able to address it. Thank you.
Thank you, Judge.
Billy Goings,
Thank you.
thank you. Good morning, Mr. Goings. Sir, you're before the court this morning on a misdemeanor capias. This is related to a charge for petty theft. I find probable cause. And Mr. Farberick, I'll go to you first.
Judge, with regards to Mr. Goings, he did want to try to resolve the case today.
Okay, is the state able to make an offer?
Yes, Your Honor, the state's offer is an adjudication and time served with no return to the location.
Okay, what's the location?
It's Publix, located at 8101 West Sunrise Boulevard in Plantation.
Okay. All right. Mr. Goings, do you understand that offer?
Yes, ma'am.
Do you wish to accept that offer to resolve this case today?
Yes, ma'am.
All right, I'm going to ask you a few questions before we're done. So to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Goings, once again, do you understand everything we've discussed here this morning?
Yes, ma'am.
Okay. Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Okay. Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
All right. Have you ever been treated for mental or emotional illness?
No, not really. I'm bipolar too.
Okay,
I
well,
don't know.
let me ask you this question. Is there anything about any mental or emotional illness today that impacts your ability to accept this plea?
No, no, ma'am.
Okay. All right. And Mr. Goings, do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication of guilt with time served, and there will be a no return order to the Publix that was discussed. And you understand that, sir?
Yes, ma'am.
Okay. All right. Good luck to you, sir. Thank you. Michael Fillmore.
Man, jail, he's approaching.
Thank you.
Judge, I can tell the court Mr. Fillmore wished to try and resolve the case today as well.
Okay. Thank you. Good morning, Mr. Fillmore.
Good morning, ma'am.
Mr. Fillmore, you're before the court this morning on a charge of trespassing on an occupied structure or conveyance. I find probable cause, and does the state have an offer for Mr. Fillmore?
Yes, Your Honor, the state's offer is an adjudication, time served with no return to Galuppi's Restaurant, located at 1103 North Federal Highway in Pompano Beach.
All right, thank you. Mr. Fillmore, do you understand that offer that the state's extending to you?
Yes, I do, ma'am.
And do you wish to accept that offer to resolve this case today?
Yes, I do, ma'am.
All right, I'm going to ask you a few questions before we're done. So to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. And Mr. Fillmore, do you understand everything we've discussed so far this morning?
Absolutely, ma'am.
All right. Is anyone forcing you to resolve this case?
They are not.
All right. Are you under the influence of any drugs or alcohol?
Not yet, ma'am.
Okay. Honesty is key. All right. Do you need any more time to speak with your attorney?
Eternity. No, not involving this case, ma'am.
Okay. All right. That's fine. And do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, I do, ma'am.
Okay. Have you ever been treated for mental or emotional illness?
No, not at this time, ma'am.
Okay. Were you ever treated for it?
No.
Okay. Is there anything about any mental or emotional illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
I do, ma'am.
All right. And Mr. Fillmore, what plea do you wish to enter? Guilty or no contest?
No contest?
Okay, that's fine. I accept your plea and I find that it is freely and voluntarily given. And once again, your sentence will be an adjudication of guilt with time served, and there will be a no return order to that restaurant location that was discussed. Do you understand that, sir?
Yes, I do, ma'am.
All right. Thank you very much, Mr. Fillmore. Good luck to you.
Yep. God bless BSO.
Thank you. All right. Okay, Alexander Margadin.
Man jail.
Thank you. All right. Good morning, Mr. Margadin.
Good morning, Your Honor.
Sir, you're before the court this morning on an ad charge. This is a new charge for robbery without a firearm or weapon. I find probable cause, and I will hear the parties' recommendations, beginning with the state.
Your Honor, the state's requesting a $5,000 bond. That's the amount for the other ones.
He's being held no bond on the other charts. So you have 1, 2, 3 other no bond cases, plus he has other 5,000.
Okay. All right. And Mr. Farbrook, over
Judge,
to
the
you.
only thing I would ask on his behalf, he's posted apparently a $90,000 bond with all of the other bonds that are there.
Okay.
I think this may be the only thing holding him in light of the fact that his bond is so high for all of the other charges combined. I would just ask the court to consider RORing him with regards to this count. If not, I would ask the court to set a $1,000 bond.
Does he have a no bond hold on him right now?
If he has an out-of-county bond hold, Judge, I would just ask the court to set bond at $1,000 so he continues to get credit time served with regards to this count.
Your Honor,
Mr. Margadin, I don't want you to say anything about the facts of the case, all right?
I won't, Your Honor, I promise. I just want to say that all the other out-of-county holds have been resolved. They've been taken care of.
Okay, well, just so that you know, they're still showing in our system as no bond. So, if there's something, well, let me confirm with confinement, yes.
Some of them are saying security bond, and then some of the charges for no bond. So we just paid some of the ones that had bond amount.
Okay, so the out-of-counties that had bonds attached, she's posted for. Okay, but there are some that are no bonds. Okay, so Mr. Margadin, I'm just gonna repeat that one more time, okay? It seems that on some of the out-of-county bonds, or some of the out-of-county holds, there were bond amounts which have been posted, but there are still some that remain that have no bond holds, meaning that there is no bond to be posted on those, okay? I just want you to understand that.
Your Honor, I just want to say I was transferred to Palm Beach County for 4 months.
Okay.
And all of the charges that were in Palm Beach, they gave me time served for. So all of them are resolved. I don't know why it's still showing in your system that there's still bonds or no bonds, because everything that was in Palm Beach County has been taken care of.
Okay, all right. I'm not sure what's going on with those since they're not in front of me, but if they're still showing, then you might want to talk to your attorney about it to see what's going on, okay?
All right.
All right, in the case that is in front of me today, the bond will be set at $3,500, and there will be a no return order to the Sprint store that is located at 29 South Federal Highway in Deerfield Beach. Mr. Margadin, do you understand that you're not to go to that location?
I understand, Your Honor.
All right, thank you very much. Good luck to you.
Thank you.
Shaquan Roberson. Thank you.
How you doing? Good morning.
Good morning, Mr. Roberson.
How you doing?
I'm well. And Mr. Roberson, I think we discussed yesterday that you're going to be in today, all right?
Yes, yes, ma'am.
Okay, so you're here on an ad charge this morning. and this is a charge for grand theft. I find probable cause, and Mr. Roberson, this has $1,000 bond on it. Because
Yes,
I realized we discussed yesterday what was going on with your other ones, I'm gonna go ahead and leave the standard bond in place on this one as well, okay?
Okay, that's fine.
All right, thank you very much. Good luck, sir.
All right.
Christopher Cozart.
Copy, y'all.
Thank you. Good morning, Mr. Cozart.
Good morning.
All right, Mr. Cozart, you're here this morning on an ad charge. This charge is for second-degree petty theft, third or subsequent offense. I find probable cause. I see the standard bond is $750. Is the state seeking anything beyond the standard bond?
No, Your Honor.
All right, Mr. Barbarick, I'll go to you.
Judge, I did have the opportunity to speak to him. He is single. He's lived here all of his life. He's not working. He has no money in the bank. He lives with his mom and his sister. He doesn't believe that they can afford to help him either. And so at this point, even with the $750 bond, I don't believe that he would be able to bond out. So I would ask the court to consider an ROR or pretrial release. If the court's not inclined to do that, I would ask the court to set the bond as low as possible.
What else is holding Mr. Cozart?
Oh, I have other charges, ma'am.
I know, Mr. Cozart. I'm just checking with confinement. Hang on one sec.
He's been held on grand theft, driver's license suspended, fleeing disregard for personal safety, three counts of
Got bonds on all those?
Judge, in light of that, I would ask for a $500 bond.
All right, I will set the bond at $500, and there will be a no return order to the Publix at 9951 Miramar Parkway in Miramar. Mr. Cozart, you understand that?
Yes, ma'am.
All right, thank you very much. Good luck.
All right, thank you.
Denzel McFadden.
Mr. McFadden refused to attend this morning, Your Honor.
Okay, I think this is his second reset. Was it a refusal? Oh, it was a refusal. I have a note on here. It was refusal last time. Okay. In light of this being Mr. McFadden's second refusal, I am going to make a finding of probable cause in absentia. I see that he has a no bond hold on his parole violation, so I will hear the parties' recommendations on counts 1 and 7 in his case.
Your Honor, with regards to count 1, state will be seeking $3,500, and for count 7, I believe, $1,000.
$1,000 on 7?
Yes, Your Honor.
All right, Mr. Farber, do you have any input?
Judge, I would just ask for 1,000 on count 1 and 500 on count 7.
All right, I am going to set the bond on count 1 at 3,500, and I will set the bond on count 7 at 1,000. And I realize that Mr. McFadden isn't here, but I am going to place a no return order on his file. All right. Thank you. Okay. Douglas Mason. Good morning, Mr. Mason.
Good morning, Your Honor.
All right, Mr. Mason, you're here this morning on a felony violation of probation. I find probable cause. And Mr. Mason, this has a no bond hold on it, which means that you'll be going before your division judge soon, so that judge can address how it's going to be handled, all right?
All right, I have SOR in Palm Beach, so how am I supposed to report to them if I'm here?
Well, you have access to the phone, so you'll be able to call them if you need to. But in the meantime, you should be going in front of your division judge soon. So I don't have a date for you right now, but just know it'll be soon, okay?
So no bond?
No bond for today. All right, good luck, sir.
Thank you.
Enrico Nelson. Thank you. Good morning, Mr. Nelson. All right, before I proceed with reading the charges, I want to confirm with the state on counts 5 and 6. It seems that there should only be one of those. Am I missing something on that? According,
Just a moment, Your Honor.
according to the paperwork I have, it seems there should only be one. Yeah, 5 and 6, they both are reading burglary of an unoccupied conveyance unarmed, but when I read the, so my finding sheet is what is not correct. Is that what you're telling me? No, his booking is showing the same thing on my my finding sheet is. 5 and 6 are both showing as burglary and unoccupied conveyance. Well, it doesn't help me if it's in the comments section. Count 6 is supposed to be criminal use of personal ID.
Sheet that I have, both counts 5 and 6 are both burglary unoccupied conveyance.
Yeah, I see what she's talking about. If you look at the booking sheet on count 6, in the comments, it says criminal use of personal ID, which when I read the PC, that seems to support that. It's just for whatever reason they did it incorrectly when they processed it. So I'm just making the correction on my finding sheet. All right. All right, Mr. Nelson, hopefully I've got it right now, okay? You're before the court this morning on 8 charges. Count 1, burglary of an unoccupied conveyance unarmed. Count 2, grand theft. Count 3, illegal use of a credit card. Count 4, fraud, use, or possession of ID of another person without consent. Count 5, burglary of an unoccupied conveyance unarmed. Count 6, criminal use of personal ID information. 7, illegal use of a credit card, and 8 is second-degree petty theft. I find probable cause, and I will hear from the parties at this time.
Your Honor, with regards to count 5, the state is requesting a $5,000 bond.
Judge, I can tell the court that he's lived here all of his life, that he has no money, he's not currently working. He does have family members that are here that can possibly help, but he can't afford the bonds as they're set, irregardless of count 5. So I would ask the court to consider either releasing him ROR with regards to count 5 or setting the bond at $1,000.
All right, I'm going to set the bond on count 5 at $5,000. I will leave the other bonds in place as they have been set. There will also be orders of no return and no victim contact. All right, Mr. Nelson, so that you understand these orders, that means you're not to return to the location that is at issue in the case. And with respect to the no victim contact order, whether you know the alleged victims or not, that means no being in the same place at the same time as these individuals, no phone calls or text messages to these people, and no third-party contact or social media contact with them. Do you understand that?
Yes, Your Honor.
All right, thank you very much. Trinidad De Leon.
Good morning,
you.
Your Honor.
All right, good morning, Mr. De Leon.
Hello, good morning.
All right, sir, you're before the court this morning on 2 charges. These are each felony violations of probation. I find probable cause. And Mr. De Leon, these have no bond holds on them, which means that you'll go in front of your division judge to have that judge address the matter further.
Two felony charges. What are those? If you don't mind.
These are violations of probation, and they are related to charges for grand theft auto and 3rd-degree grand theft uttering a forged instrument. Okay, so Judge Merrigan's put a no bond hold on them, so you'll have to go in front of him so that he can decide how to handle them. All right, you'll get a hearing notice shortly. All right, good luck to you, sir.
Okay.
Thank you. Robert Harrison. Good morning, Mr. Harrison.
Good morning, Your Honor.
All right, Mr. Harrison, you're before the court this morning on 2 charges. Count 1 is a felony violation of probation, which has a no bond hold. And count 2 is a misdemeanor capias related to a charge for trespassing. I find probable cause. And Mr. Farbrick, are you making any request on count 2 in light of the no bond hold, or you want to just leave it?
Judge, it's a municipal ordinance, so based on that, I would just ask to leave it.
Okay. All right. So, Mr. Harrison, since you have the no bond hold, that means that you'll be going in front of your division judge shortly so that you can address that matter. All right. Good luck, sir.
Ma'am, what the trespassing charge? I don't remember. Can you read me the arrest report? Because I never had a trespassing charge.
So, since you're here on a capias in that matter, sir, I don't have the actual original the original arrest report, but you will be able to contact your attorneys after the hearing today so they can get that information to you. All right?
Ordinance. I don't understand why you're not handling it.
Because you have a no bond hold in a felony case. So you're going to have to go in front of the division judge anyway. So you'll be able to address everything at the same time. All right?
Okay, and one more thing, Your Honor. I have
Yes.
a lawyer. Her name is Monique Brochu of Fort Lauderdale.
Okay.
She doesn't accept collect calls, and I don't have my cell phone anyways. I need to get in contact with her.
Okay, so let me just ask, Mr. Farbrick, are you familiar with that attorney?
I know her, yes.
Okay.
I can look it
Would
up.
you reach out and let her know?
I will.
Okay. All right.
Please,
So,
it's very important.
okay, so they're going to reach out to your attorney and let her know so she can get in contact with you. All right, good luck, sir. Okay, next will be Michael Stafford.
Angel, he's approaching.
Thank you.
Good morning, Your
Okay,
Honor.
good morning, Mr. Stafford. All right. Mr. Stafford, you're before the court this morning on 2 charges. Count 1 is kidnapping. Count 2 is robbery with a firearm. I find probable cause, and I will hear from the parties beginning with the state at this time.
Your Honor, the state is seeking a no bond hold. Proof evident, presumption great.
Mr. Farbrick, I'll go to you next.
Judge, my response to that is that, as the court knows, that's the highest burden that the state would have to prove. Proof evident, presumption great. This case stems from 2014. The client has been in custody in the Department of Corrections up until this point. Why the state hasn't filed since 2014 in the last 6 years, I'm not understanding. They certainly could have done that. There may be issues with regards to time periods, statute of limitations and things of that nature. What we would be asking is for the court not to find proof evident presumption great in this case. I would ask the court to set a bond in this case. Like I say, this is a case that's 6 years old, and I understand he was in custody, but there's no reason that the state didn't initiate these charges long before this. And there may be a question as to whether they can even go forward at this point.
Okay. I appreciate the arguments that you've made with respect to any issues regarding statutes of limitations or anything like that. That's obviously not before me today. Based on the information I've been provided, I do understand this is a 2014 case. However, in light of the circumstances, I am going to make a preliminary finding of proof evident presumption great at this time in order that Mr. Stafford be held no bond. However, that will be without prejudice for him to have the appropriate Arthur hearing with his division judge. And as I said earlier, I do know that the felony judges are making time and efforts and arrangements to hear these hearings, so he will be able to get in front of a judge as soon as necessary. There will also be an order of no victim contact and an abundance of caution. Mr. Stafford, so that you understand the no contact order with respect to the alleged victim in this case. I understand that it's a 2014 case, but I'm going to say it in an abundance of caution. That means no being in the same place at the same time as this person, no phone calls or text messages with this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, ma'am. I've been in prison for the past 2 years, Your Honor.
I understand, Mr. Stafford.
My EOS date is Monday. I'm just asking for a fair opportunity to be able to fight this case from the street. This is allegedly happened when I was a 16-year-old juvenile. I'm 22 years old now. This happened 6 years ago. They said all they have is a cotton swab on the DNA for a cell phone.
All right, well,
I have
Mr.
no
Stafford,
idea.
I want you to just stop because I don't want you to say anything else about
No,
the case today, okay?
I promise I won't say
All
nothing
right.
else about the case.
Okay, understand what I'm going to say to you. The finding that I've made today is without prejudice. So if your attorneys need to file the appropriate motion, they can get that in front of your division judge soon, and you'll be able to address it with that judge to see how it's going to be handled. All right? So good luck to you, sir. Ulrich Brown.
Good morning.
All right, good morning, Mr. Brown. Mr. Brown, you're before the court this morning on 2 charges. Count 1 is aggravated battery with a deadly weapon. Count 2 is felony battery. I find probable cause, and I will hear the parties' recommendations, beginning with the state at this time.
Your Honor, the state's requesting for count 1 a $10,000 bond amount, and for count 2 $5,000.
All right, Mr. Farberick will go to you next.
Judge, I can tell the court that he is single. He's lived here for 20 years, that he's an air conditioner technician. He does have a little bit of money in the bank. He said his family may try to help him, but they may not have a lot of money to help him with. I would be asking the court to set bond at $1,000 on each count.
Does Mr. Brown have priors? All right, the bond on count 1 is going to be set at $10,000. The bond on count 2 will be set at $2,500. There will be an order of no victim contact as well as a no return order. Mr. Brown, those orders mean that you are not to return to the location that this allegedly occurred at. And with respect to the no victim contact order, that means no being in the same place at the same time as the alleged victim. It also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, Your Honor.
All right. There will also be an order that you possess no weapons, firearms, or ammunition. So if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes, Your Honor.
All right. Thank you very much. Good luck, Mr. Brown. Next will be Josiah Mack.
Main jail is approaching.
Thank you. Good morning, Mr. Mack.
Good morning, Your Honor.
Mr. Mack, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied dwelling, unarmed. Count 2, battery on a law enforcement officer. I find probable cause. And is pretrial standing? Go ahead.
The defendant was placed on pretrial supervision on February 23rd in case number 20-2071 CF10A. one count of burglary of an unoccupied dwelling and a count of burglary unoccupied conveyance. As I was reviewing the probable cause on this case, it appears that this incident occurred prior to him being placed. He, in essence, did not violate his pretrial supervision. And so I'm going to ask the court if you're inclined to place him back on pretrial with this case. I'm checking to see, I believe he was occupied with an electronic monitoring. That he had on that original case. Does look like there was an electronic monitoring.
He was on pretrial with a GPS?
Yes.
Okay.
So he
Level
that
2.
did not violate it, so that's why we're asking for him to go back with
Okay.
on this case.
Okay, do the parties wish to be heard?
That's fine, Judge.
It's
Anything
fine,
to say?
Judge.
Okay, all right, in light of pretrial's recommendation and the information that has been given, I will release Mr. Mack to pretrial. That means he will be ROR'd on counts 1 and 2. Mr. Mack, this case will be placed on pretrial supervision, just like your other case. That will be with a level 2 GPS monitor. There will be an order of no return and no victim contact with respect to the location and the alleged victim in this case. That means you are not to return to the location that is issued in this case. And with respect to the alleged victim, whether you know this person or not, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand?
Yes, ma'am.
Thank you. Thank you. Derek Baker.
Main jail is approaching.
Thank you.
Yes, Your Honor.
All right, good morning, Mr. Baker.
Good morning.
Sir, you're before the court this morning on one charge of battery on a person 65 years of age or older. I find probable cause, and I will hear the parties' recommendations. We'll begin with the state at this time.
Your Honor, the state is requesting a $5,000 bond.
Judge, I can tell
And no victim contact, sorry.
Okay, go ahead, Mr. Farbrick.
Judge, I can tell the court that he would not be able to afford that. He has been a citizen here or a resident of Florida all of his life. He's not currently working. He receives Social Security disability. His disability requires him to take medications as well as visit a doctor once a month. So based on that, Judge, we would be asking the court to consider either releasing him or releasing him to pretrial release. If the court's not inclined to do that, I would ask for a bond of $1,000. And I don't know that he'd be able to afford that either.
Mr. Farbrick, does he have a permanent residence?
Sir, do you have a resident? What residence do you live at?
Yes.
What's the address?
It's 51 28th Street.
Okay. Mr. Baker, do you live there by yourself or with someone else?
I stay with other people there.
Okay. Do you rent a room there, or what's the living situation?
I pay a amount of money there, like about $700 and about $50 a month.
Okay. So is it a private residence and you rent a room there?
It's a group home.
Okay. All right. Does Mr. Baker have priors?
Your Honor, part of the reason that the state is asking for the bond amount requested is due to the fact that this happened at the living facility. The victim also resides at this living facility. In 2006, there was a battery on a detention facility staff member. That case was actually, it was dropped. In 1993, he had a robbery with firearm or deadly weapon, and he was adjudicated on that, and another count of robbery with firearm or deadly weapon that he was also adjudicated on. They're all pretty old cases, Your Honor.
Well, I'm willing to put Mr. Baker on pretrial supervision, but they would have to verify that he's gonna be able to come back to that location, because if in fact the victim does reside there, he's not going to be able to return there.
Mr. Baker, is there any amount of money that you would be able, or your family would be able to help you post bond with?
Hold on. Go.
It'll be like about $3,000.
Okay. Judge, what I would ask for in this case is $1,000 to set bond at $1,000. The only reason I wouldn't place him on pretrial release with verification is if they can't verify or he can't go back to that address.
Right.
I don't want him to be stuck with no bond and no way to get out.
All right, I will set the monetary bond at $3,000. And Mr. Baker, there is going to be an order of no victim contact. So with respect to the alleged victim in this case, until further order of the court, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that?
Yes.
All right, thank you very much. Next will be Anthony Bones.
Main jail.
Thank you. Good morning, Mr. Bones.
Hey, how you doing, man?
I'm well, thank you. All right, Mr. Bones, you're here this morning on 2 charges. Count 1, resisting an officer, obstructing without violence. Count 2 is a felony probation violation with a no bond hold. I find probable cause, and I see he's got the no bond hold. Do the parties wish to be heard on count 1?
I just ask you to keep the bond the same.
Okay. All right, so Mr. Bones, since you have that no bond hold, that means you'll be going in front of your division judge soon, so that judge can address how that's gonna be handled. All right, good luck to you, sir.
Yes, ma'am.
Okay, next will be Christopher Hoy.
Please approach him, ma'am.
Thank you.
Good morning, Your
Mr.
Honor.
Hoy. Good morning. All right, sir, you're before the court this morning on 4 charges. Count 1, DUI, alcohol or drugs, 4th or subsequent offense. Count 2, driving while license suspended, 2nd offense. Count 3, refusing to submit to a DUI test. Count 4 is improper backing, which is not for magistrate. I find probable cause, and I will hear from the parties.
Your Honor, the state is requesting a $5,000 bond with pretrial release and TAD.
Judge, I would ask, he's lived here for approximately 3 to 4 years. He's recently married. He said that he has a few $100s. I would ask the court, but his job is one that works with the public, and so that I don't know that he would have that job at this point, based on the pandemic. What I would be asking is the court to set bond on count 1 at $1,500 and to leave counts 2 and 3 as no charges.
You said 1,500?
Yes.
One moment, Your Honor.
So the most recent was 2014? Bond on count 1 will be set at $3,000. I will not attach bonds to the other counts. However, if Mr. Hoy does post his monetary bond, he will be placed on pretrial supervision with a TAD monitor. He will be subjected to random drug and alcohol testing. And there will be an order that he not be driving. I believe that his license is suspended, so that should go without saying, but I'm going to say it to be very clear. Mr. Hoy, with respect to the requirement that you be subjected to random testing, that means no alcohol and no intoxicants until further order of the court. You will be wearing a tab monitor, which will also monitor that. There is also an order that you not be driving. As you just heard me say, from what I can see, it appears that your license is suspended, so you shouldn't be driving anyway. But I'm saying it so that we are crystal clear with each other. You are not to be driving any motor vehicle until further order of the court. Do you understand that?
Yes, ma'am.
All right, thank you. Jamal Muhammad.
Miguel, he's supposed to.
Good morning, Your Honor.
Good morning, Mr. Muhammad. Sir, you're before the court this morning on 2 charges. I'm sorry, his bond was posted? Okay, Mr. Muhammad, I'm being told your bond has been posted. So for the record, I find probable cause and you'll be processed for release.
All right, thank you.
Good luck, sir. All right, and last on my list is Waldez Jean.
No brows on it.
All right. Thank you, Deputy.
Welcome.
Good morning, Mr. Jean.
Good morning, Your Honor.
Mr. Jean, you're before the court this morning on 4 charges. Count 1, grand theft auto. Count 2, false ID given to law enforcement. Count 3 is a felony probation violation with a no bond hold. And count 4 is driving while license suspended, third or subsequent offense. I find probable cause. I do see, I'm not sure what the prior hearing was with Judge Lerner Wren, but I do see it seems that she placed RORs on counts 2 and 4 already. Okay, so he's got a no bond hold on 3 and $1,000 bond on count 1. Do the parties wish to be heard?
No, Your Honor.
Okay.
No, Your Honor.
All right. So I will place an order of no victim contact with respect to the grand theft auto charge. Mr. Jean, the no contact order means whether you know the alleged victim or not, no being in the same place at the same time as this person, no phone calls or text messages to that person, and no third-party contact or social media contact. Do you understand?
Yes, ma'am.
All right. Additionally, since you have the no bond hold, that means that you'll be going before your division judge shortly so that you can address that matter further. All right. Good luck to you. All right. That brings us to the end of our morning docket for first appearances. The afternoon first appearance docket will be starting at 1 p.m. this afternoon. Thank you, everyone.